Fantastic Tutor, and in today's tutorial, it's going to be a continuation on the course PCR271. It's actually a very long one. It is about volume 10, and we still have more class to go to cover the old material. Alright, so with this being said, let's get straight into it. So we have PCR 271. I want to talk about international law tonight. Okay, talking about international law. And when we say international law, what are we talking about? Okay, according to what we have in the material, right? But just before we go into that, I would like to remind us, I would like to emphasize on the fact that everything we are going to take in today's class is basically for educational purpose. Okay, it's basically for educational purpose. This is an educational content. We are actually using the material, all right, in line with the material of the National University of Nigeria, just all right, helping students to understand their material, their course material better by actually discussing topics, by actually expanding on some topics and helping to highlight some key points for expansion or for better explanation. All right, so the contents being taught on this stream is basically for educational purpose and not to especially courses that has to do with war, courses that has to do with conflicts and how it can be managed. It is basically for educational purpose. It's not to instigate conflict, it's not to instigate war or thereabout. It's basically for educational purpose. All right, so now let's go straight into it. So today we have the topic international law. Okay, now this is said to be the body of laws which is composed for its greater part, okay, of the principles and rules of conduct which states feel themselves bound to observe and do commonly observe in their relation with each other. Now let's take note of this. Let's take note of the following point. It says it is a body of law. A body of what? Of law. First thing to note, it's a body of law and principles, and also rules. And who does this, or who are the set of country, or who does this rule bind, or who does this principle govern or guide, and who are these people or countries that the rules and principles are meant to guide? Good evening, Miss Florence. I'm seeing that name for the first time on the stream. It's great to have you on board, Miss Florence. Is this your first time on the stream? Are you a member of a private class? All right. Please, if it's your first time, do want to subscribe to the channel and smash the like button. And also, there's a private class whereby we have a lot of resources going to be giving, a lot of resources I will be giving out to students now that exam is getting close. Now, as I was saying, it is a body of law, principles, and rules of conduct, which, all right, rules we have of conduct, which, okay, states, okay, which states bound to observe, which states are bound to observe in their relationship, which states internationally are bound to what? Observe in their relationship with each others. Now let's look at the key points here. This is a body of rule, principles, all right, rule of conduct, just like what we have in countries, but particularly international law is out there to guide how countries, different countries, relate with each other. Rules, principles, rules of conduct that these countries are expected to observe when interacting with each other. Then we have the international law. All right. Now it says here it comprises. Now there's a listing of about 2 points. It says it comprises of rules of relating or functioning. Okay. It says it's comprised of rules of law relating to the functioning of international institutions. Rules, okay, of law relating to what? The functioning of international functioning of international what? Institutions. International institutions. Okay? Or organizations. So we have that as that. Secondly, it says there are certain rules of law relating to individual and non-state entities. Individual and non-state entities. Okay? So as far as what is concerned, rights or duties. As far as rights and duties are concerned internationally. Are we together? As far as rights and duties are concerned internationally. So we have that as that. So now let's take note of this point. It says here that in the 18th and 19th century, witnessed, okay, the great development. Witnessed the what? Great development of international law. Okay, witnessed the great development of international law. So we have that stuff. Now let's proceed. So we have, it says there are so many assertions about the real origin. All right, so many theories, so many philosophies about the real origin of international law, or how international law emerged or came into being. Okay, now some school of thoughts, based on the fact that there are so many assertions, there are some school of thoughts are of the view that the modern system of international or law of nations. So now take note that international law can be interchangeably used, can be substituted for law of nations. All right. So please, this question might pop up in the exam. Should be able to handle it. All right. International or law of nations is a product of about 100 years ago. All right. Some school of thoughts, according to their belief, that the modern system of international or law of nation is a product of about 400 years ago. Now, take a look at this. In ancient, okay, now let's continue. Now, let me permit me to raise the board so we can take some points because we need to take down some points now. Now we have the International Law Commission work has led to the creation of number of treaties and other work of international law that are key to the present international legal order. Now it says here that so let permit me to use IL. Anywhere you see IL, just know that it is international law. Now the International Law Commission, all right, International Law Commission, the works of International Law Commission has what led to the creation of treaties. Now, when we say treaties, what are we talking about? All right, treaties is like an arrangement of peace between nations, arrangement of peace, different nations or states coming together to have a peaceful arrangement, establish peaceful relationship, and anything that just has to do with peaceful interaction and relationship is more of a treaty. All right, and it says here that international law. Now, have you even ever wondered why we even have this international law? Now, let me tell you something. You see, in line with this treaty and international law, now we've seen cases whereby some countries, based on the fact that they feel that they are powerful, they are stronger, they just want to use the opportunity to submerge or subjugate some other countries or nations that are not as stronger as them. All right, and we've seen this through the line, down the line of history, whereby conflict here and there, and the conflict won't just end, passed down from generation to generations. All right, so now the history of this international law is as a result of treaties being created between these countries, and therefore imposing, or therefore, let me not use the word impose, therefore introducing law that will guide international communities, law that will guide international states, whereby if any states go against this law, then other nations or other states will rise in support of the country that the right has been infringed, just to ensure that such country get justice. So we have international law just to guide, all right, to put in check, just like we have law in our country whereby it is to put in check and ensure that everything goes smoothly, just to put in check the relationship and interaction between countries, so that you know that okay, if I'm doing this now, I know that I'm going off tangent, and I might be violating certain laws which are international based. All right, so bear that in mind. That is where international law came into being. Now let's continue. Now look at what it says here. It says the two major sources creating legal binding rules of international law are what? Treaty and custom. Two major what? Two major sources of international law. They are treaties. Two major sources of international law. They are treaty and custom. Okay, we are about 5 of us on the stream, and I'm seeing just 3 likes. Please, be on the stream and are yet to smash the like button, kindly smash the like button. And if you are yet to subscribe to the channel, kindly subscribe to the channel. And if you are yet to become a member of our private class, you might be missing a lot. because in the private class, we will be giving to students, our members, a lot of helpful resources just to help set up for their exams. Resources like exam keynotes, resources like TMA solutions for studies, all right, and resources like exam practice questions, all right. So you don't want to miss out all these helpful resources that can help you stand a better chance at attempting exam. So now, speaking of treaties, all right, treaties is the first major contemporary source of international law. Please take note of that. The what? The first major, okay. Sorry, and I said I forgot to say something when I was talking about the private class. If you want to reach out to me, please, you can reach out to me directly on www.tutorio.com. That's our official website. Then on the website, you get to see the WhatsApp icon at the top right hand corner. Smash the WhatsApp icon, and it takes you directly to my DM, and you can chat me up personally. All right. So now, speaking of treaty, it's said to be the major source. All right, it is said to be the major contemporary source of international law. All right, first major contemporary source of international law. Why? Treaties are said to be what? Bilateral. I think I need to open treaty could be, are we together? Bilateral, which is said to be between two states, between two states, and multilateral, which is between, okay, more than two states. Let's take note of this. It could be, treaty could be bilateral or multilateral. Now, treaties, as we said, generally speaking, all right, they are binding only upon the state parties to any particular treaty, and the nature of obligation will be defined within the treaty. Now, the world covers a multitude of international agreements and contracts between states. All right, agreements and contracts between what? I already made mention of this before now. Agreements and contracts between states. All right. Now, before we can say we want to have a treaty, it has to be the thing. It has to be agreed first. Just like the case of bringing in somebody to help, we call them we call them an intermediary. All right. When it comes to resolving conflicts, the both parties must first entrust that, okay, we submit to you that you can handle this case. Now, when it comes to treaty too, it's not imposed on any of the party. It has to be what both parties want. Both parties must first agree to it. If not, it will not work, because there will be an agreement. All right, and there will also be a contract. I want to talk of contract. All right, we are talking about certain agreement that both parties are in support of, and if you go against it, there are repercussions. All right, so it is said to be an agreement and contract between states. So it is more of a peace contract, a peace agreement, not like business. Okay, it's more of peaceful. It has to be peace and all this likes. All right, so thank you for that. Now let's continue. We have customary international law. Now we said something about custom and treaty. Now, speaking of this, it is not easy to understand the concept of international customary law, all right? But according to Article 38, two elements are said to be required. Now, the first is the custom itself, but only custom which evidence a general practice accepted as law. All right, when we talk about custom, we are simply talking about a particular practice, a way of life that is peculiar to a particular group of people, or that is peculiar to a particular state, society, or community. All right, and this has now become a way of life. This behavior has now become a way of life, then it becomes their custom. All right, so now that's why I say that it's difficult to, all right, it is difficult to identify, because speaking of international customary law, we are talking about different countries in question. Okay, now the first is the custom itself, as it is said that there are two elements required in the customary international law. Customary international law, two elements, which you have the custom. It says here two elements. You have the custom itself. All right. Custom itself. Okay. So we said it's an evidence of a general. Evidence of what? Evidence of a general practice. General practice. Okay. Accepted as law. Accepted as what? As law. Then we have the other one. The name is somehow. So let me use another sheet of marker to. It's called opinion juris. All right. Opinion juris. Okay, it's longer than that, but let's just short it there. Opinion juris sive necessitatis. All right. I think there's an English pronunciation to that. It says opinion as to law or necessity. So let's just take that. Opinion as to law or necessity. Opinion as to law, or what we call necessity. Okay. Opinion as law or necessity, which means that only where a state complies with the custom, all right, in belief that it is legally required to do so, will law be evidence. Just as it says here, opinion as to law or necessity, which translates to that the only where a state complies with custom, only when a state complies with custom in the belief that it is what? Legally required. When custom is now seen as a legal requirement, this is when law is evidence. All right. So don't forget, we are talking about international states now, not just locally. So now it is made up of these two elements. That's customary international law, the custom, number one, and the opinion as to law or necessity. So we have that as that. So now let's take a step further. Now there's something here. It says in the 19th century, international law was very much more concerned with describing, all right, describing the actual conduct of states in their relationship with each other. All right, the actual conduct. International law is very particular with what? Describing the actual conduct what is the expected conduct between states. All right, in we even have, their work, their jobs, that there are ethics guiding them. All right, we call them work ethics, your conduct at work, your disposition on duty. In the same view, international law in the 19th century was very much particular and concerned with describing the conducts when a nation is interacting with another nation. What is the proper conduct to guide this relationship so that it doesn't get out of hands? All right. So we have that as that. So there are other sources. Okay, we talked about just treaty and custom, but there are other sources as well that we also made mention of, that they are also sources of international law. Speaking of general principles, all right. Speaking of, let me put that in a red marker. Let me write down with a red marker. So we have general principles. General principles of what? Of law recognized by civilian nations. General principles of law. General principles of law recognized by civilian nations. And also we have judicial decisions and the teaching of most highly qualified, all right, publicists of the various nations. So let's just take this point. Judicial decisions. Also we have judicial decisions. So we have that as that. So I want us to take down some of these points before we call it a wrap for today. Now, it says here, the first peace Hague Conference was convinced, all right, in 1899, all right. But now let's take this down. Let's leave that for now. Let's take down this abbreviation, ICRC, whereby we have International Committee of Red Cross, International Committee of Red Cross. Okay, International Committee of Red Cross. And okay, just a moment. I also have the ICTY. We have International Criminal Tribunal. International Criminal Tribunal for the former Yugoslavia, for the former Yugoslavia. Established in 1993. Okay. We also have the ICC, which is the International Criminal Court, International Criminal Court. Okay, so let's take down these points. It says in August 2005, the Iraqi Transitional National Assembly approved the creation of War Crimes Tribunal in August 2005. So we have on November 5, 2006, Saddam control have the material. Hussein was convicted of crimes against humanity, by a Baghdad court, and was sentenced to death by hanging. Now there's something called war crime. I really want us to touch on this, but that will be in our next class. Okay, where we'll get to talk about. I think that our next class will be our final class. So we'll talk about war crimes. I'll get to know more about this person and what he did. Okay, so but let's just call it a wrap here for today. I think the next class is on Friday. It's going to be the final class on this course. Like I usually say, we don't teach everything on the YouTube class. All right, we keep some very important thing to students in the private class, because definitely it is because of them that we are here. If there are no students in the private class, we can't be here on YouTube. So thank you very much, everyone. Please let's do well to keep our notes up to date and submit them to the appropriate quarters. I remain your one and only tutor Ayo, the enthusiastic tutor, and I look forward to seeing you all in subsequent tutorial. To have a wonderful night rest. Good night.